You should be able to hear me now. Audio over the top TV. Is that better? By top mark, I'm saying audio on top mark now. Settings, black matrix design. Let's do. Not sure why it's not working very well. I might just have to record locally and then repost it. Was I buffering on this side? Okay, right now I'm sending audio, but I don't want you to have this audio when when Court was live. My idea was over on Top Mark. You guys can hear me now on Top Mark because I'm sending you my Roadcaster feed. My idea was to just have the Court feed, but StreamYard, in their infinite wisdom, have updated their system to not allow me to include audio from a share screen. Not sure why. Okay. Let's see if I can launch a little application to fix that. What happens if I just give you channel 2? Okay, I've got an idea. Hold tight. I can route video differently. Output 2. Oh, webcam output is going to be camera 2. See, this looks good, right? And now I just need to make sure you've got audio. And I can do that by playing my stream on camera 2. Recovery Addict. Okay, so over on Top Mark Media, are you able to hear this? I'm not sure if you can hear me or not. Yes. But now I've got an inception problem. EDB says there's a lot going on and changing with StreamYard. I think they got bought or something to that effect, but she has also stated lots of things changing, not for better. Yes, first of all, they doubled their pricing and lessened their quality. Okay, so now do you just hear one of me over on Top Mark? Let's see, you only want Blackmagic Design. I'm not sure if I can just route audio from one source or not. We'll try. Sure if I can just route audio from one source or not. We'll try. Sure if I can just route audio from one source. It's like echo. We'll try if I can just route. All right, so here's what I need you to do. On Top Mark, I'm going to play this hearing, this lawyer disciplinary hearing from the other day.
The VA, I was.
And can you hear this audio? No. Man. Well, it was fun while it lasted. I'll just record it locally. Lanier says, you think you got issues. A 16-foot of section of our fence blew down last night. Santa Ana winds in SoCal. Oh, my goodness. And you guys have fires down there as well, which is just terribly dangerous. Inception is not my favorite movie.
Rather difficult to adjust to
All
mentally.
right. So,
because day in, day out, your mind is on top-level felonies. And because there's an allegation, of course I'm going to tell them. I have no requirement to tell them, but these are going to be men that are going to be my partners in hopefully in a few short years. I told them about this investigation. I told them, look, I didn't take the money. I did not steal the money. I did not misappropriate. And I showed them the bank records. I tried to get this handled as quickly as possible so that they wouldn't be suspicious. And the fact that this drug on until the beginning of this summer, the closed-door conversations where you can't be here. You're not being honest with us. There would not be an ongoing investigation of you for misappropriating client money.
You can hear the court, but you can also hear my voice, right, over on Top Mark?
Because they saw the complaint. The complaint said you stole $42,000 from a client. That's not insignificant. Even the suggestion that that could happen, and the fact that the case remained open for that long, it was, you need to excuse yourself. We're not going to embarrass you by firing you, but you will not be here. And then I couldn't open my firm after that. And so I'll find some.
All right. So my brain is full, and I can't figure out how to make that work. So we're just going to skip. We're not going to have a clean feed. Pretty sure a Trial TV Live is going to grab a clean feed. I love that when you search for my channel, it says, you're not alone. Free confidential helpline. That's because I chose my name poorly. Let's see. Idaho 4th District Court. All right. We'll have it live on the Recovery Addict channel, and we'll go from there. I'm going to go ahead and shut down. Well, I'm just going to dual stream to Top Mark. How about that? There you go. Now you get me on Top Mark, and you get me over here. It needs your burner number. Burner number is 513-1160 with the area code 801. That is a Google Voice number. All right, as far as time goes, we've got about 27 minutes before court begins. There may be another 20 minutes after that where they decide whether or not Bryan Kohberger can wear a suit to court. I keep getting blurry. I'm watching, it's funny because I'm watching my own feed through Top Mark Media, and I'm not seeing it get blurry. So that might be an internet issue on your side. I am pushing a higher quality stream than I've ever pushed before now that I've got this better camera. So you might have slower internet that is struggling at the highest level of clarity. Going back to our schedule here for what's coming up. We're looking at we wanted to look at the speedy trial complaint. So I'm going to pull that up and see where their complaint of speedy trial was. You've got filings under seal. Request for appointments and transfer of case. What? This was on the 9th of last month. There's a resource judge. Not sure what that means. Let's see. Non-statutory aggravating evidence. Got the aggravators. Death penalty. Vagueness, international law. Arbitrariness. Standards of decency. Motion to strike grounds speedy doesn't permit effective assistance. What? What? Hang on. I need to find the original. Speedy trial doesn't allow effective assistance. He wanted the speedy trial. Let's get down to Kohberger's. Okay. Kohberger, all the motions having to do with speedy trial. Order stay in time for speedy trial, that was 7/7/23. Amended order stay in time was 7/10. Motion to reconsider order stay in time for speedy trial was 7/17. Response to state's motion to consider order stay in time for speedy trial 7/24. Waiver of speedy trial on 8/23. Okay, waiver of speedy trial. He's waived it. Order denying defendant's motion to stay proceedings and withdrawing order stay in time for speedy trial. This has been an issue for a while. Objection to motion to strike state's death penalty on grounds of speedy trial. See if we can see what it says here. This is a response. So they must have filed this under seal. I think they filed this under seal, and now we've got a state's response, but I don't have the original listed, so it must have been under seal the first time. Comes now the state of Idaho by and through Latah County Prosecuting Attorney, and hereby objects to defendant's motion to strike the death penalty on grounds of state speedy trial, preventing effective assistance of counsel. Defendant claims that this court must strike the death penalty because he cannot be forced to choose between his right to a speedy trial under the Idaho Constitution and his constitutional right to effective assistance of counsel. His argument rests entirely on an inaccurate premise that the Idaho Constitution sets a hard and fast 6-month deadline for his trial. Because the Idaho Supreme Court has held otherwise, this court should deny the defendant's motion. All criminal defendants in Idaho have a constitutional right to a speedy trial pursuant to both the U.S. and Idaho constitutions. The right to a speedy trial under the U.S. Constitution is assessed by the balancing of 4 factors. 1, the length of the delay. 2, the reason for the delay. 3, whether the defendant asserted the right to a speedy trial. And 4, the prejudice to the defendant. This approach has been adopted in Idaho for determining whether a speedy trial violation has occurred under the Idaho Constitution. In fact, the only difference between the federal and state constitutional rights to a speedy trial identified by Idaho Supreme Court is when the speedy trial clock begins. The clock begins for the federal right at the time of arrest, and for the state right at the time of arrest or the time the charges are filed, whichever occurs first. From there, both state and federal constitutional claims turn to the balancing test under Parker. Predictably, the case-specific balancing test adopted by the Idaho Supreme Court has resulted in a wide variety of municipal lengths of delay before trial. Delays from 15 months to 17 months to 2 years have all been found permissible under Idaho's Constitution. The defendant attempts to free himself from this well-settled case law simply by opening that Idaho Supreme Court has wrongfully deviated from the right to a speedy trial as it was defined by the framers. It's going back to the original Constitution, as read on the parchment, envisioned it differently. He holds with this court to hold the decisions of the Idaho Supreme Court were wrongly decided. So he literally is saying the Supreme Court is wrong and you should overturn them. He asked this court to assess sides with legislatures of other states and draw a firm line at 6 months. Unfortunately for the defendant, that is not how constitutional interpretation or law generally operates. The Idaho Supreme Court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. One defendant's fatally flawed premise is corrected. Once defendant's fatally flawed premise is corrected, his alleged Hobson's choice between the right to a speedy trial and the right to effective assistance of counsel is not a choice the defendant has to make at all. In fact, the Idaho Supreme Court has expressly held that it's constitutionally permissible to delay trial is so defense counsel has adequate time to prepare. That one's not going to fly. The speedy trial thing, this motion to strike or speedy trial is gone. Lack of grand jury, he's raised the grand jury issues before, didn't like through a grand jury. But then international law, let's see where that one comes in. Okay. Objection based on international law. There it is. International law. The objection to this part right here. This for you. The motion to strike is based on international law. Right here. The motion is 481 pages long. Pages. Motion to strike states notice of intent to seek death penalty on grounds of international law. And memorandum in support of the motion. So they attach to German law. It sounds like it. Bryan Kohberger, attorney, moves the court to strike the notice of death penalty on grounds that Idaho's death penalty scheme violates its allegations of international treaties. Idaho's death penalty procedure violates the provisions of international treaties and the fundamental precepts of international human rights because international treaties ratified by the United States courts. The imposition is unlawful. U.S. Constitution. Article 6, Clause 2. Lots of case law. It's like a paragraph long citation. Mr. Kohberger also maintains that violating international law violates his right to the 14th Amendment to the United States Constitution, as well as Section 13 of the Idaho Constitution. Now to the international treaties. You guys know the first fact what the first international treaty was? Or the first international, all the countries got together, decided something. That's what researchers are. I think it was about birds. On December 10th, the United States General Assembly adopted the claims that the Declaration of Rights. United States General Assembly resolution. The United States was one of the 48 states that adopted the Declaration. 48 was 48 votes, 49 against, and 9 abstained. The Declaration of the first series of the rights began the Nations Commission for Human Rights. In 1988, the United States signed a convention against torture, cruel, and degrading treatment or punishment in 1994. In 1977, the United States signed an international convention on economic, social, and cultural rights, but did not ratify it. The International Convention on Civil Rights, Political Rights, which ratified in 1992. The court was requested pursuant to Idaho rules to take position notice of true, incorrect, challenge against each of these instruments hearing reference. So they copied all the international law. Here's a quick international covenant on civil rights, or the ICCPR, which prohibits inhumane or degrading treatment or punishment prohibits the arbitrary deprivation of life. Every human has the right to life. This right protected by law, arbitrarily deprived. This isn't arbitrary. This is after a criminal proceeding where they're found guilty. In countries which do not abolish the death sentence, may be for the most serious crimes with the law, enforce the time out condition of not contrary to the provisions of the Convention on the Prevention of Punishment of the Crime of Genocide. This penalty can only be carried out pursuant to a formal judgment rendered by a competent court. The judge is going to say, I agree, and we are. I'm not talking about dissenting votes to ratification. They are digging deep. This is crazy. Most importantly, this court misunderstands that the ICC does not permit Senate claims to have done. The whole country is wrong. Kohberger is right. Our laws are right. Bryan is right. This is audio is really distorted on top mark. I'm gonna shut down top mark then. Sorry guys, thanks for the fun.